Hey, 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 I should be live on the YouTubes. At least that's what my computer is telling me. Perhaps there's a slight delay. Oh, here we go. All right. Welcome, everybody, to the first ever Law of Self-Defense. Attorney Andrew Branca, live stream on YouTube. I'm glad you could all join me. This is going to be a bit of an experiment here. It's my first time using this interface to stream to YouTube. We'll talk about some law for sure, use of force law, some cases in the news. And but a big part of today, I'm afraid, will be kind of a technology test demonstration, trying to get this old boomer to figure out how to use this interface. So thank you all for coming and being the experimental subjects for today's broadcast. Let's see what I can do here. There's a bunch of buttons. Share a screen. Okay. Share. Share a screen. Let's see. Sorry, folks. Part of this is really the best way to learn how to use all this is just to go ahead and use it. So let's try that again. Share a screen. I know, exciting stuff. Sorry, folks. I simply can't get this to work properly. Let me see. Maybe I need to put something on the screen. Ba, 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 ba. Now I'll try again. And that is just not working. All right. Well, screen sharing is might have to wait until another time, folks. This is trying to share the second monitor I have here through StreamYard. For those of you asking, let's see. Well, okay. I promise all of you to get your money back on this broadcast. Hold on one moment, folks. I'm going to step out just for a second and see if I can get some help here. All right, I'm back, folks. It looks like there's no way for me to share the screen. I had to change a setting that Chrome requires, or my computer, my iMac requires me to reboot Chrome, which would obviously lose this stream. So I'm not going to do that. Let me do a little else here. I'll scroll through the comments and see if questions have come in that I can address in a useful way. Let's see. Lots of stuff. Thank you all, by the way. Emily, Mrs. Branca, who just over a week ago had surgery for breast cancer, is attempting to assist me on this broadcast. She declines to come on camera for obvious reasons, but she's doing quite well in her recovery, and we continue to have every expectation of a positive outcome. So we thank your good wishes and prayers and so forth. It's all much appreciated. Let's see. So here's an interesting question from Christopher. He says, is it okay for the spouse to call 911 instead of myself? Should we be at home and an intruder breaks in? Since she is not a shooter, would it look better in court for her to be the caller? So presumably you're at home. There's some kind of use of force event. Somebody's trying to break into your house. Hypothetically, you've used a firearm, deadly defensive force in defense of your property. Now there's a guy bleeding or dead, and you need to call 911. Who should make the call? Frankly, it really doesn't matter who makes the call to 911. It doesn't need to be the shooter. It can be somebody else. The shooter might be otherwise occupied, either keeping eyes on the suspect who is breaking into your home, or perhaps even providing first aid to that suspect, depending on how you view such things. It's generally better, by the way, folks, for the person you shoot not to die. You generally want that person to live. You want to neutralize the threat to yourself and your family. Of course, safety first. But it's generally better if the person doesn't die. If they die, you're looking at much more serious criminal charges, murder or manslaughter charges, as opposed to aggravated battery or aggravated assault charges. And you get the interest of much higher level prosecutors. Prosecutor careers are often made on murder trials, killing trials. It's one of the most important statistics for them from a personal and professional level. So you don't want that guy. You don't want the maximum amount of prosecutorial expertise, drive, resources brought against you in a criminal trial, which is what is likely to happen if the person you've shot actually dies. So if you can prevent them from dying, there's certainly legal advantages to doing that. Again, only so long as you can do so consistent with safety. When professional EMS shows up, they don't begin treating anybody until the scene is secured. So if the scene is still dangerous, if the professionals wouldn't begin treatment, that would be a good argument for you to not begin treatment either. But in terms of who calls 911, really the more important issue is, so in our law of self-defense class, we spend almost an hour talking about interacting with the police in the aftermath of a use of force event. And there are distinct interactions, by the way. It's not simply one interaction. So anyone who gives you one answer for, should you talk to the police, hasn't really thought through this dynamic, because you'll have the interaction with 911, meaning somebody distant on a phone. They're not personally present. You'll have a second interaction with the first responders, the people who come in response to the 911 call. They are physically present. And they're initially at least to secure the scene. And then you'll have an interaction with detectives, probably a different group of people who are there to actually investigate what happened, collect the evidence, and so forth. 3 different interactions. They each need to be treated differently. And we spend quite a bit of time talking about just what you might want to say to 911. And for people who say nothing to the police, I have to ask, well, do you plan to call 911? Because if you're calling 911, you're saying something, right? You're not just dialing the phone and remaining silent when they answer. 911, what's your emergency? You're going to say something. That's why you called them in the first place. So if nothing else, to give your location so resources can be sent to where you are. And at that point, you're talking to the police. So it's worth thinking about even just what you might be willing to say to 911. And we spend a lot of time in our class talking precisely about that question. But I often get the sense that the students in the class learned quite a lot from that. But what if it's not them calling? Or what if it's not them speaking with the police at the scene once the first responders arrive, or speaking with detectives? They haven't thought through these issues at all. They were not sitting in the class, unfortunately. So I think it's less important who actually calls 911 in this home defense scenario that was posed by Christopher than it is the person making the call informed about what they should and should not say? Have they thought through these issues? If you've informed yourself by attending our class, for example, have you also had that conversation with your loved ones who are likely to be in your company when an event happens, whether you're at home or out in public at some event? And if they're present, I can assure you the police will want to talk to them too. And have they given any consideration to the advantages and disadvantages of saying what and to whom in which of those distinct police interactions? Because if they haven't, it doesn't matter what you know, how you've informed yourself, what you're prepared to say or not say in your interaction with police in the aftermath of a use of force event. If your loved ones around you who are also having that police interaction have not had that education, well, you have a loose cannon in your midst, and obviously not because they're there with any form of malice. They're just literally ignorant. I don't mean that in a derogatory sense. I mean that in a technical sense. They're uninformed about the risks and benefits of saying anything in particular. So my advice would be to be less concerned about who's making the call on your behalf, whether it's you or your spouse, and be more concerned about whether or not they know how to do that in an informed way. And of course, a great way to do that in an informed way would be to take advantage of our Law of Self-Defense advanced class coming up on Saturday. I wonder if I can share this. Saturday, January 8th, which is just about a week and a half away. It's closing in fast. I'll see if it'll let me share my home screen. Nope. In any case, our upcoming class, we only teach this class once every year or two, folks. It doesn't come up very often. It's a pretty arduous day for me. It's me talking for 8 hours straight. I know Nick Ricida does that all the time, but that's not normally my gig. So we don't teach it very often. It is live. It's taught by me live in person. Well, in person over Zoom. We broadcast it to your computer using Zoom. And there's plenty of opportunity for live Q&A, much as how we're doing live Q&A here, except Zoom has a better format for that kind of thing than we do here. That's January 8th, Saturday, about a week and a half away. If you'd like to learn more about that opportunity, I would encourage you to point your browser to, well, it's right there in my image, lawofselfdefense.com/advanced to get access to that not very often taught class. I wanted to talk about the Burlington Coat Factory shooting, and I have little clips of video and such to share with all of you, but unfortunately, for this broadcast, it appears that I'm unable to share that video. It's all publicly available, but the key points, I guess, don't really require the video. So this was in North Hollywood, California. There was a man inside the Burlington Coat Factory beating people with a bicycle lock. At least one person pretty darn badly. She was bleeding on the floor. He was dragging her across the floor. Police were called. Everybody was panicked. At least one person who called the police informed the dispatcher that the suspect had a gun. That turned out not to be true, but it was information provided to the police, upon which presumably the police relied. They're allowed to do that. That's a fact then known to them. And you can tell if you watch the video of the police coming into the store, they're not entering with the expectation of meeting an unarmed suspect. They're entering what they apparently believe to be an active shooter scenario. They've got their guns out. Everybody has a gun in hand or some form of projectile weapon, mix of AR, shotgun, pistol. There is a beanbag gun as well, which is not really an ideal weapon if you're going up against a gun-armed suspect, but that's probably doctrine. If you have enough officers, one of them is carrying the less lethal weapon option. And they move into the store, and they move in pretty quickly because that's what you do with an active shooter situation, folks. After Columbine in Colorado, nobody sits outside anymore. They flood the building with law enforcement. They believe there's a distinct possibility in an active shooter scenario that the bad guy's walking around shooting innocent people. I mean, the videos of Columbine, I don't believe were ever made public. I've seen them through contacts at the FBI. It's horrible. Those two monsters were walking through that school, just casually shooting people huddled under desks and tables. begging for their lives. And all law enforcement has seen those videos. So that's what the cops think they're stopping when they enter an active shooter situation. So they go in fast and they make fast decisions. And in this particular case, the officer armed with the AR turned, looked down an aisle in the store, saw the suspect moving quite quickly with a black object in his hand that would turn out to be the rather large black bicycle lock. And the officer fired, I believe, 3 rounds into the suspect, mortally injuring the suspect, and tragically, due to an overpenetration, also mortally wounding a 14-year-old girl who was out of sight behind a wall in a dressing room. No possible way for the officer to know that people were there, but she was also struck and killed. And this is, frankly, exactly the kind of situation where you would expect the parents of the child to file a wrongful death suit in civil court, and you'd expect the politicians who run the city and the department to agree to a rather substantial settlement over the tragic death of their 14-year-old daughter. What you would not expect to see here is criminal liability for that death, because criminal liability requires either intent to cause that injury to the 14-year-old or reckless conduct, meaning a conscious disregard of the risk of causing the injury to the 14-year-old girl. And the conscious disregard also has to be unjustified conduct. And the use of deadly defensive force on these facts, believing the suspect to be an active shooter, seeing a victim lying on the ground right at the officer's feet, blood all over the ground, looks exactly like someone would look if they'd been shot by an active shooter and was being dragged across the floor. It seems very clear to me that this was a justified shoot. And keep in mind, it's justified until the state can disprove it beyond a reasonable doubt. And I don't see on these facts the state coming even close to being able to disprove the justification of defense of self and defense of others based on the reasonable subjective perceptions of the police officer. Remember, he doesn't have to be right about what's happening. He has to have a reasonable perception about what's happening. And if he reasonably perceives a deadly force threat, and I think that's reasonable on the facts of this case, then the use of deadly defensive force is justified here. So that's the Burlington Coat Factory scenario. If you have questions or thoughts on that, feel free to put them in the comments. I'm going to continue scrolling through the comments. Let's see. Yeah, I see someone mentioning my book. Thank you for the kind words on the book. We do have hardcovers available. This is a version of the hardcover. If you'd like to get that, you can get that at lawofselfdefense.com/gethard. lawofselfdefense.com/gethard, and we'll get that book out to you. If you'd prefer to buy it at, I believe you can still get it on Amazon as well. In any case, there's lots of reviews on the book on Amazon, about 1,000 reviews, solid 5-star rating. So if you'd like that kind of verification of people's perceptions of the quality of the book, then you could always take a look at those reviews at Amazon. Let's see what else here. Yeah, so most of you will probably be familiar with Nick Rekieta Law. He's got a very popular YouTube channel as well as on other platforms, Odyssey and so forth. I don't really know how well that works. And he's been kind enough to have me on the show a number of times. It's always great fun, and frankly prompted me to try doing a little bit of this myself, which is why we're here today. And Nick is having a very interesting interview today with attorney Earl Gray. Earl Gray was one of the attorneys for Kim Potter, of course, along with Paul Eng. And I feel terrible, but I suddenly can't remember the name of the female defense attorney. She didn't play much of an active role in court. I believe her first name was Amanda. I don't mean to suggest anything negative about her because I can't remember her name. She just wasn't really an active participant in the trial. But in any case, Nick will be interviewing Earl Gray today. So that should be extremely interesting. I believe that is at 1 p.m. Central Time at Rekieta Law. If you're not familiar with Nick's channel, I would encourage you to go take a look. I'll be watching that interview myself. Nick's, I don't believe he's going to have any guest lawyers on for that, just because of the nature of the interview and the limited amount of time he's going to have with attorney Gray. But he may have some of us on to comment after the interview. I believe that's his intent. Let's see. Yeah. Oh, I guess I'm supposed to say things like smash the like button and subscribe. I believe if you want to subscribe, if you want to comment, I believe you need to be a subscriber to our channel. So that would be helpful for you to do that. We always appreciate that. I don't even know what the like button is, to be honest. But presumably there's a like button on there someplace. There's a versus the subscribe button. Let's see. Oh, and thank you all very much for the super chats. I don't know if I'll be able to answer every question that's put in the comments, but I will certainly address anything that's highlighted for me as a super chat for sure. Boy, there are a lot of comments. Yeah, I don't know how Nick does his show. Someone said Nick never sleeps in the comments. It certainly seems that way to me. I certainly cannot keep up with that guy. It seems like he's working 24 hours a day. Let's see. Well, it looks like even I get a few of my trolls. Let's see. Yeah, so someone here mentions law enforcement seems to always analyze and judge how the person sounded when they called 911. Keep in mind the responding officers don't hear that call. So they don't hear the stress in the caller's voice. The dispatcher hears that, of course, but the dispatcher stays a dispatch. They're not responding to the scene. And the information they pass on to the officer is usually passed on in to the extent it's audible, it's in a relatively calm voice. That's their profession, to try to communicate to the responding officers as clearly and calmly as possible. And of course, much of the communication is also in text form, sent to the computer in the responding officer's patrol car. But even though the responding officers don't hear the 911 call in the moment, I can assure you if they've been an officer for any period of time, they've responded to a lot of scenes of violence, and they know what they're going to encounter when they get there. So they have a pretty good idea of what is likely to be happening, how stressed out people are likely to be, scared, frightened, terrorized when they get to the scene. That's what they're expecting, based, of course, on the information provided by the dispatcher. Let's see. So one big difference between those of you familiar with Nick's Ricardo Law channel and mine is I really do only use the force law, so I will not be covering topics like Jack Murphy. I will leave that to Nick's domain. He has a much broader interest in the general world and streaming content than I do. Yeah, folks, so somebody mentions here that I'm not going to say anything substantive in today's show because I'm going to save it for my class. Actually, if you watch enough of my content, eventually you'll hear me say everything that I say in the class. It just might take you a couple of years to get that comprehensive coverage. What I cover in the class is not secret. It's things I apply and talk about all the time, but not in a comprehensive way like we do in the class. In the class, you get all of it in roughly 7 hours or so, including all the live Q&A that we do. Someone asked, in a scenario in my property, he specifies California, but it doesn't really matter. Outside the home, can one use self-defense in the driveway and around the home? Well, you can use self-defense as a legal justification for use of force anywhere. You can use it in prison if you happen to be a prisoner. It doesn't matter where you are. Now, the conditions that might be required can vary depending on where you are. You generally get greater latitude to use defensive force in the context of your home, ideally within the four walls of your home, than you would out in public, where you don't have a right of exclusion where anybody can be. Many states have special provisions that create a legal presumption that you have a reasonable fear of deadly force harm from someone forcibly and unlawfully entering your dwelling, for example. You don't have the benefit of that presumption if you're just out in the street. Every jurisdiction has some form of the castle doctrine, which properly understood merely means that if you would have had a legal duty to retreat before defending yourself out in public, you're relieved of that legal duty to retreat if you're inside your home. There's lots of flavors of castle doctrine, but that's the general principle. So that's how where you are can impact some of the conditions for self-defense. If you're in your home, you generally lose that requirement of avoidance, if avoidance would otherwise have been required. By the way, California, many people are surprised to learn, is a very aggressive stand your ground state in terms of law. You won't find a stand your ground statute in California because they don't have one, but the law is not just statutes, folks. The law is really a combination of statutory law created by the legislature and case law or court-made law created by the appellate courts. In fact, relying solely on a plain English reading of a statute can be extremely dangerous because the statute doesn't mean what the legislature might have hoped it would mean or what they intended it to mean when they passed it into law. A statute means what the courts say it means when they interpret and apply that statute to real people in real cases. So if you've only read the statutory language and have not read the case law around that statute, you don't really know what that statute means. It doesn't necessarily mean what a plain English reading of the statute would suggest. So one of the best ways to get that combination of statutory law and case law or court-made law is to look to the jury instructions. The jury instructions are a consolidation of statutory law and case law. So they're the entire body of the law, and they're generated by the courts themselves. So it's how the courts, the appellate courts in particular, how the appellate courts want that law applied to the facts of a case. And they're generally written in something resembling plain English, which court decisions are not usually, unfortunately. But of course, jury instructions are intended for people who are not legal professionals, for a lay audience, for jurors. So they're generally written in plain English. So if you can get the jury instructions, that's generally the best option to learn how the law would actually be applied in a particular case. Unfortunately, there are a lot of states where it's pretty hard to get the jury instruction. Some of them just post it online, freely accessible, like they do with their statutes, for example. That's very helpful. Some of them make it much more difficult to get a hold of. Even for attorneys, there's some states I have to pay several $100s a year to get access to their official jury instructions. So it really varies by state, but the jury instructions are the way to go if you can get it. And in California, by the way, if you look at the California self-defense statute, it's about, I'd say it's about 250 words in length. If you look at the California jury instruction on self-defense, it's about almost 600 words in length. So it's more than double the content of the statute, the jury instruction. And by the way, for those who'd like to look at those, you can look at the California jury instruction. If you go to lawofselfdefense.com/197, that's for Penal Code 197, lawofselfdefense.com/197, you can pull up the California deadly force self-defense statute. And if you go to lawofselfdefense.com/505, that's for the jury instruction, Cal Crim 505. You can pull up the California jury instruction there. And what you'll see in not in the statute, but in the jury instruction, because it's from case law, is the stand your ground provision in California law, that under California law, you not only don't have a legal duty to retreat before you can defend yourself, you actually have the privilege to pursue your attacker if necessary for your safety. It's right there in the jury instruction. So that would be read directly to the jury before they begin deliberations. Let's see. And by the way, if anyone's taken our class before, we've called it different things over different times. We've called it our level 1 class, our core class. Now we're calling it our advanced class. It's really the same class. It's 7 or 8 hours of content. It's the equivalent number of hours as if you were taking a law school seminar on self-defense law, an hour at a time over a course of a semester. So that's why we refer to it as the equivalent of a law school seminar on self-defense law. If any law school taught use of force law at this depth, which really they don't, folks. In my 3 years of law school, we spent maybe 5 minutes on self-defense justification, and that was only in first year criminal law. And that was it. We lawyers are not generally taught this stuff in any depth in law school, unfortunately. We do often, when we teach this class live, which I really haven't done in 3 or 4 years now. By live, I mean in person. As a travel class, so I travel to some other location, some other state to teach this full-day course. In that case, we generally get it accredited for CLE, which is continuing legal education for attorneys. And we get quite a number of attorneys, judges, prosecutors, also law enforcement, although law enforcement doesn't need CLE credit. But we have a lot of legal professionals come to our class and routinely tell us it's the best continuing legal education they've ever had. In fairness, probably because most CLE sucks, but we like to think it's because we do such an exceptional job teaching this stuff at a level that satisfies legal professionals while also teaching it in plain English, so it's understandable to even people who are not legal professionals. And again, you can learn more about that class. It's Saturday, January 8th at lawofselfdefense.com/advanced, just like you see on the URL here. Yeah, in the Burlington shooting, it's so some of it shouldn't matter, right? What color the officer was or what color the victim was. In a just world, we wouldn't care about such things, but we live in the world in which we live. And unfortunately, everything is racially hyper politicized, which is a contemptible way to run a country, but here we are. So it may well play a factor in whether or not to charge this officer and to what extent. And by the way, I don't think any criminal charges would be appropriate for this officer. I think his use of force was completely legally justified. And the death of the 14-year-old is just really a genuinely tragic accident. Folks, I got 4 kids myself. I can't imagine what those parents must be going through. But just because it's tragic doesn't mean it's criminal. Nevertheless, of course, we see many cases in which people are prosecuted criminally, despite the lack of legal merit for those charges. That theoretically could happen here. It seems less likely to happen, given that it appears from what we can see in the body cam video that the police officer who fired the shots that killed the suspect and the 14-year-old happens to be apparently African American. Shouldn't matter, but it probably will. Let's see. We have a question here. What should be in mind when considering using force to protect yourself or others? Well, I can't answer that in a 2-sentence reply. The best thing I can tell you to do is come to our class, January 8th, Saturday, lawofselfdefense.com/advanced. Let's see. Oh, Doug here says he gave both his adult sons a copy of my book. That's a great gift. I hope they make the effort to read it. By the way, it's a very easy to read book, folks. Most people tell me that they can read it in an afternoon, 3 or 4 hours. You get through the entire thing, and it's to a certain extent it's a book form of our full day class. The biggest difference really is not so much the substantive content, but the fact that in the live class we have this kind of give and take, and I can illustrate what I'm discussing with current day events to just make everything clearer, more concrete, more understandable. The book obviously is fixed from when we revised the last edition a couple of years ago, so it wouldn't include reference to cases like Kim Potter, for example. Kevin asks, can the juror interview be used on appeal? So I wanted to talk about that too. Apparently one of the jurors was interviewed by the media in a news story published yesterday. And what we learned from that juror, first of all, I should say, it's very common for jurors when they acquit in a highly politicized case to be basing their verdict on the evidence and laws presented in the court, as they're supposed to do, and coming in good faith to a verdict of not guilty. And then they go back to their communities and they discover that many people in their community now consider them racist for having acquitted a defendant who, in fairness, the community has often been told for a year or 2 that the suspect is a terrible racist murderer. And they hear that thousands of times over a year or 2 period, and they come to believe that it's true because that's the only side of the story they're hearing. So when their neighbor comes home after jury service, having acquitted someone they've been convinced, brainwashed, use your own term, is a racist killer, well, they can't imagine how that could possibly have been their neighbor's decision. And afterwards, then the neighbor says, oh my gosh, everyone hates me. Everywhere I go, people hate me. I can't go to events. I'm getting the cold shoulder. Maybe there's protests outside their home. Maybe their job is endangered. Maybe their kids are getting hassled at school, or their spouse is taking heat for their not guilty verdict. And those people, those jurors, will often do interviews where they're trying to explain away the verdict, to direct the heat away from themselves. They'll say things like, well, if only we'd seen this piece of evidence that the judge had excluded from trial, so we didn't know about it, or we didn't learn about it till after the verdict. If only we'd known that evidence, we would have voted to convict, or if only this had happened or that had happened, or some other excuse, basically, for explaining away how they arrived at a not guilty verdict. And they're doing that for reasons we can all understand, to direct heat away from themselves. So I never believe those interviews. I just assume those jurors are just lying for perfectly understandable reasons, to explain away their not guilty verdict. When a jury votes guilty, however, the dynamic is quite different. In these hyper politicized cases, their neighbors are not mad at them for convicting the suspect that they believe, the defendant that they believe was a racist killer. They're not getting heat for that. If anything, they're getting praise, and they're seeking more praise when they do these interviews. So these interviews, I think, are also self-serving, but less likely to be based on lies or misdirection. I think you're more likely to be getting honest, maybe not truthful in an absolute sense, but genuinely believed information, sentiments, recounting of what happened in the jury room in cases of a guilty verdict, like in the Potter trial, than in a not guilty verdict, like the George Zimmerman trial, for example. So I expect the jurors here in this interview is telling the truth as she believes it. And frankly, the most telling thing that she mentions in the interview is that they convicted Kim Potter despite apparently all of the jurors believing that her shooting of Dante Wright was simply a mistake. They decided to attach criminal liability to a mistake. And you can't challenge that it was a mistake. I mean, even Kim Potter clearly indicates she was not intending to use her gun. No one believes she knew she had a gun in her hand when she fired that shot. She believed she had a taser in her hand. Clearly, all the evidence is consistent with that. That's a mistake, but a mistake is not sufficient for criminal liability. That's the misjustice, the miscarriage of justice in this case. Criminal liability would require that she consciously disregarded the risk of shooting Dante Wright dead, that she knew she had the gun in her hand and was waving it around anyway, and then it unintentionally discharged, for example. But that's not what happened here. And that's why this conviction is unjust. And now, partly, of course, because the prosecution, in their rebuttal, meaning the last statements made to the jury, no opportunity for the defense to correct any of this, any misinformation given to the jury, but the prosecution, Matthew Frank, misinformed the jury on what the law requires in order to convict. He explicitly told the jury that the state does not have to prove that Kim Potter knew she had her gun in her hand, which they do. And the judge did not correct that misdirection. So that paved the way for the jury to come to an improper verdict, attaching criminal liability to a mere mistake, not requiring a showing of conscious disregard of risk. And for that reason, Kim Potter should not have been convicted. Frankly, she should not have been tried on these reckless manslaughter charges, because there is no evidence consistent with conscious disregard of risk here. The charges should be dismissed. There's another case I was going to discuss today, but I can't share my screen. But it was a very similar case. Another female police officer accidentally deployed her gun instead of her taser, shot a suspect. I believe that suspect survived. This was in Kansas in 2018. And she was charged with some form of recklessness, criminal conduct. It might have been reckless endangerment. If the suspect died, it would have been reckless manslaughter, as here. But in that case, the trial judge dismissed the charges prior to trial because he said, well, there's no evidence of conscious disregard of risk. That's what should have happened here, instead of this travesty of justice that we have in Kim Potter. Now, Kim Potter will certainly appeal her conviction. I think she has very sound basis for appeals. Whether or not the appellate court wants to address this issue at all is really up to them. I mean, Judge Chu should have addressed this misstatement of law, and she chose not to. The appellate court could do the same thing. So we'll have to see what happens there. One of the issues is, of course, one of the concerns you always have is, generally speaking, jurors don't explain how they arrived at a verdict. They're certainly not required to explain how they arrived at a verdict. And if there's multiple ways they could have arrived at a guilty verdict, and some of them are legally sound, and one of them is legally defective, well, it may not be clear that it was the defective path that led to the conviction. So we don't know, in fact, that there was actual error by the jury. In this case, with this interview, can the interview be used on appeal? I would certainly use it on appeal because it goes to the juror's mind process, thought process in arriving at a guilty verdict on grounds that are not captured within reckless manslaughter under Minnesota law or the law of any other state, that they were willing to convict on the grounds of mere mistake as opposed to conscious disregard. So I would certainly use that interview on appeal. Let's see. What else do we have? Yes, smash the like button, subscribe, all that. Let's see. So here's another question, and maybe from the same person who asked about self-defense on property. There are, as I mentioned before, you often get special provisions of law that kind of expand or broaden the conditions, relax the conditions under which, for example, deadly defensive force would be permissible if you're on your property. But there's different flavors of property. You'll get the most protection if you're inside the four walls of your house and someone is unlawfully and forcibly breaching those four walls. You get less protection if you're inside the home, but they're outside, or if you're both outside, but in the immediate vicinity of your home, in the curtilage of the home, the area immediately around your home that's part of the normal day-to-day life of the home. So a front yard, a backyard, a driveway, things like that, as opposed to if you live on 40 acres and you're on that 40th acre. That's probably not going to be within the curtilage of your home any longer. Curtilage is a very ambiguous legal doctrine. It's not black and white defined. Sometimes you'll see a state will have a curtilage statute that does include specific things, like it will explicitly say curtilage includes a front porch and back porch, which is always nice. But it actually includes more than that, and the statute doesn't really define what the more is. Also, a lot of curtilage law is not created in a use of force context. It's created in a search and seizure context. When do police need a warrant to search items on your property? Generally, the courts say you have an expectation of privacy within the curtilage of your home, as well as within the four walls of your home, and therefore the police would need a warrant to search your curtilage, even though it's not within the four walls of your home. But curtilage defined in that context, search and seizure, warrant context, is not necessarily the same as the scope of curtilage in the use of force context. So you have to be very careful about that as well. It's much the same as that discussion I had with the lawyer, Natalie, and I just don't recall her last name, on Nick's show, where a question came up during the Kim Potter case of whether or not the argument was you should not even tase someone who's operating a vehicle, and therefore Potter's intent to use a taser would have been unjustified because Dante Wright was operating the vehicle as defined for DWI purposes. And operating a vehicle for DWI purposes includes almost anything, folks. I mean, slipping the key into the ignition is operating the vehicle for DWI purposes. But the scope of operating the vehicle for DWI purposes is not the same as the scope for operating a vehicle for can you tase that person purposes, because the risks are different. Absent any kind of use of force event, if someone's operating a vehicle, it's reasonable to infer they intend to actually put that vehicle into motion. We don't generally just hang out inside our cars. In a use of force context, the risks are completely different. What we're concerned about there is that the person is, if you tase them, they'll lose control of a vehicle in motion and cause, become a missile, a 2-ton missile going down the street. Different risks, so different relative contexts for the same words, operation of the vehicle. In each of those circumstances. So the trouble with looking at, so you always have your normal self-defense privilege, those 5 elements of self-defense: innocence, eminence, proportionality, avoidance, and reasonableness. And then often some of those are relaxed in the context of your property. So avoidance, whether or not there's a legal duty to retreat, is generally relieved if you're inside your home, for example, under the castle doctrine. But the extent to which those elements may be relaxed in the context of property is going to be often somewhat ambiguous depending on the precise context of the property, in the home, in your curtilage, in your driveway, at the end of your driveway, on that 40th acre. And a lot of that application, like curtilage, is going to be a judgment call made by other people, made by the prosecution, the judge, the jurors are going to decide, well, do we feel like he was in his curtilage or not? And that's a judgment call made by the jury on the facts. And you don't know. There's no way for you to know where that line, where curtilage ends, is going to be drawn by your eventual jury. So I would encourage people, don't rely on those special provisions in the context of your property in terms of justifying your use of force in self-defense. I would just assume you're not going to get any benefit from those special provisions. Pretend you don't get that benefit. Just act within the 5 elements of self-defense as if you were in a public street. And then if you do get benefit from being in the context of your property, it's a bonus for you. That's the smart way to play that. Don't assume you're going to get that benefit. Let's see. Where somebody asked, where can they see the Potter juror interview? I don't know that you can see it, but if you Google it, a written news article where they have quotes from the juror will be. I don't believe they want to reveal the juror's identity. So I believe they identify the juror as male, but they don't give the name. I don't think they give the name. I'm not sure about that. But if you Google Potter juror interview, I'm sure it'll pop right up. I think I saw it on the Care 11 website. Yeah, sorry, I just don't see it right at the moment, folks. But, you know, Google is your friend. I'm sure it will be right there. Michelle Campos, thank you very much for the super chat. Let's see. She says, my issues are that Jones' colleagues were repeatedly telling him to slow down, and the perp may well have belonged in jail instead of on the streets. Well, that's certainly true. We're talking now about the Burlington Coat Factory shooting. The officers are telling each other to slow down so they can stay coordinated. They don't want to be stepping in front of someone else's muzzle, the muzzle of another officer, for example. They're not telling each other to slow down because they want to do a slow pace through the store to find the active shooter. They want to find the active shooter as quickly as they can, consistent with safe tactical practices. So that's what they're doing when they're saying slow down. They're not saying move slowly. They're saying move in a carefully coordinated way so we don't end up shooting each other by accident. And that the perp should have belonged in jail or presumably a mental institution instead of being on the streets. That's certainly true. But we live in America where we don't institutionalize people anymore, which is a travesty to them. They need help. And instead, we're pretending that they don't need help, that they're just, I don't know, being libertarians, mentally ill, drug-addicted libertarians living in horrible poverty, horrible circumstances, violent circumstances, out on the streets, protected by nobody, really, from each other, largely. And then they're free to engage in this kind of chaos that we saw this suspect commit in the Burlington Coat Factory. And I feel bad for him. I mean, obviously, I feel worse for his victims, particularly the woman he bludgeoned bloodily to the floor with that bicycle lock that he was dragging around. I mean, she obviously deserves none of this, but I feel bad for him too. He should not be in this circumstance. But we have governments that allow chaos, havoc, as Mark Richards would say, to rule the streets. And when you allow chaos, it's by definition uncontrolled. And these kind of events are going to happen, and then the police are going to show up. You're not sending a social worker to an active shooter scene, folks. That's not happening. They won't go. They shouldn't go. So the police have to go and neutralize the threat of what they reasonably believe on these facts to be an active shooter. And that's what they'll do. And if the active shooter, throws his hands up in the air and surrenders, maybe he won't get shot. But if he does anything resembling a reasonably perceived imminent deadly force threat, he's likely to get himself shot and killed, and other people killed by stray rounds. That's what happens in gunfights. Not every round hits the target and stays in the target. That's an inherent risk of using firearms, and it's a risk we accept as a society because we arm our police with firearms. Indeed, we arm ourselves with firearms. As someone who carries a gun every day for personal protection, I've never had to use that gun or come even close, but I'm well aware, and I'm fairly proficient with my firearm. Those are, for those who can look over my shoulder here, those are some shooting awards I got at various competitive pistol events. For many years, I was shooting at the highest competitive level within those shooting sports. But I know if I fire a round and it strikes the person exactly where I intend to strike them, it can nevertheless overpenetrate and hit somebody else. That's always a risk. You're not limited to using deadly defensive force, using firearms only under circumstances where it would be absolutely safe to everybody to do that. That's not possible. Let's see. Max asked, would I be recommending Potter file an appeal? Absolutely. Of course, she should file an appeal, and her conviction should be reversed. I mean, one interesting facet of the Potter trial is, in most cases, when a defendant's convicted and they appeal, and they win their appeal, which is relatively rare, they're not suddenly declared not guilty. They're just sent back for a new trial that now will follow whatever correction the appellate courts say needs to be corrected to get a just verdict this time. And often the defendant in that second trial, and sometimes there's even a third trial or a fourth trial, but often they have no resources left. They expended all their resources in the first trial, so they're basically broke for the second trial, and that's not a great place to be. Trials are expensive if you want them run the way you want them run, as if the rest of your life depends on it. I mean, just look at the expert for the defense in this case, the slip and capture expert. He's paid, I believe, something on the order of $30,000 for consulting on this case. Do you still have that money the second time around? Can you do all that again? Many defendants can't. So getting your conviction reversed is definitely a win for the appellant, but it's not an acquittal. It's just going back for another trial, a trial in which you may be less well equipped to fight the legal battle than you were the first time around, and you lost the first time around. So I often say that appeals are for losers, and that's, I mean that literally, but also in this broader sense. It's you're in a less defensible position generally in the second trial. What's different about the Potter case is if it's reversed, it will almost certainly be reversed on this issue of no evidence of Potter consciously disregarding risk. So if the appellate court says, no, that's wrong, she has to have known she had the gun in her hand. So you have to have evidence of that. Well, she's eligible to be retried by the prosecution, but if that's the legal standard the prosecution is going to be required to meet in a retrial, well, they don't have any evidence of that. So Potter's in the relatively unusual position where if her conviction does get reversed because of this misapplication of recklessness, she may not be subject to a second trial, because if that's the standard that they have to show conscious disregard, they don't have any evidence of it. At least, direct conscious disregard of the risk that actually killed Dante Wright, having the gun in her hand. Let's see. Well, it's remarkable how many people in the comments are from places other than the U.S. I hope everybody understands. And here's Fink Ployd, very clever, sir. Fink Ployd from London. I hope everybody understands that everything I say about use of force law is U.S. specific, our states, our territories, and so forth. I don't know anything to speak of about use of force law in other countries. So what I can teach you or share with you will be helpful if you ever visit America, which I would encourage you to do, but may not be particularly relevant to your jurisdiction. I mean, really wouldn't be relevant except by chance. Let's see. What gun is best for a first-time gun owner? So the first thing you should do before you ever touch a gun really is get some gun safety training. It's very simple. I'm not saying that I believe that should be mandatory. I don't think there should be any conditions, no conditions for a law-abiding, mentally sound American citizen to possess, own, and carry firearms for personal protection or any other lawful purpose. But I think it's prudent to get some gun safety training. Guns are dangerous. People do shoot themselves and other people accidentally with some regularity. You don't want that to be you or someone you love. There's really only 4 rules of gun safety. You can take a class very inexpensively from various sources, NRA, USCCA. There's others. Just, again, Google is your friend. Just to make sure that when you're handling the gun, you don't do so incompetently or dangerously. So once you've done that, safety first. We have so many great guns suitable for personal protection these days. It's amazing, far more than when I was a kid, when I was 20 or so. But it is pretty hard to go wrong with a Glock. They're not for everybody. They don't fit everyone's hand all that well, but they just work every time. They're relatively inexpensive. They're extremely common. Many police departments carry them, so it's not some kind of odd, idiosyncratic firearm that a prosecutor might try to use against you in a court of law. So generally, when people ask me, I often say, listen, if you're not sure, if you really don't know, it's tough to go wrong with a Glock. I own my share of Glocks. I personally don't carry them for personal protection. In fact, I just got a new pistol for Christmas from my lovely wife, Emily. I've been carrying a SIG 320 for, since they came out, I guess. So quite a few years now. Now I have a SIG 365 XL, just waiting on the holster for that to come in. That'll, unfortunately, the holster maker I prefer takes 3 or 4 weeks to get his stuff out. It's worth it. In my mind, I'm a big fan of his product. And that producer, by the way, is Keepers Concealment, Keepers, I believe, Concealment. I don't have any kind of affiliate or discount code or anything. I just, the owner is Spencer Keepers. I just think a lot of his product. So if you're interested in a very good concealment holster, I think all of them are appendix carry, but you'll have to check his website. Extremely, extremely good quality stuff. But it does take a while to get. So I'm waiting on that. Let's see what else. Let's see. Yeah, so Michelle asks, and thank you very much for the super chat, Michelle. When these police killings occur, usually a suspect did something to cause it. Do you think the defense attorney, and you wrote rational media, but I presume you mean national media, although it would be nice if the media also were rational. Should they emphasize this more? The media has an agenda. They run whatever version of the story fits their agenda. They're clearly hyper politicized themselves. Their business model is all based on clicks. So they'll say the most outrageous thing, spread the most outrageous lies if it will get them more clicks and more revenue. They're completely disreputable and mostly not very bright as well. So the media is just going to do what they do. Can the defense attorneys talk about it? Well, I guess in public, what they can say in court is in front of a jury is limited to what the judge will allow them to say in court in front of a jury. And generally speaking, character evidence about the suspect who was shot by the defendant is not permissible in court, absent some unusual circumstances. But as a general rule, you can't bring in character evidence about the bad guy who was shot by the defendant. So the jury's not going to hear that. They won't hear it in court for sure. So should that be different? I mean, I could make a good argument that at least in the context of self-defense cases, even if we keep the limit, really the almost absolute restriction on character evidence in court generally in place, I think a good argument could be made from a public policy perspective that in self-defense cases, it should be different. That the jury should be entitled to know who these two people were, not just the defendant, but also the person the defendant shot. Because the defendant's claiming self-defense, he's claiming I shot him because of the way that guy was acting. And the way he was acting may be consistent with his character. So I would certainly be amenable to a public policy change that allowed for greater latitude in allowing in character evidence. Now, we already have something like that in place in many courts. Many courts will allow more character evidence about the suspect who was shot if an issue in the case is who was the initial aggressor. And frankly, this really should have been allowed, like in the Ahmaud Arbery trials too. I would have made this argument more strongly. Also, by the way, even more strongly in the Rittenhouse case, the argument should have been made more strongly there too. That the state was arguing that the defendant, Rittenhouse, was the initial aggressor. So the question of who was the initial aggressor is now in dispute. And it's relevant to who was more likely the initial aggressor if the person who was shot by Rittenhouse has a reputation for violence. And Rittenhouse does not have a reputation for violence. The more violent person was more likely to have been the initial physical aggressor in that confrontation. So there are courts that open that door when that issue of innocence, that issue of who was the initial aggressor, is in dispute in the case. And I would certainly be in favor of liberalizing character evidence for that purpose, if not also for other purposes. All right, folks. Well, I only meant to go an hour, but we have a bunch of comments I still haven't gotten to. And especially I want to get to the super chat comments. Obviously, I appreciate all your support tremendously. So I'm going to scroll through a little more quickly. So Robert asks, it appears to me that Montana law, in a way, almost promotes brandishing before using deadly force. Am I wrong? I'm not sure specifically which Montana law you're thinking of, but there are a number of states who have passed what I refer to as defensive display statutes. So defensive display of a gun, typically, and they say, well, because if you merely display a gun for purpose of changing someone else's behavior, which is what you're doing when you display a gun for self-defense purposes, right? You're pulling your gun out, maybe you're holding it a low ready, you're saying, get back, or explicitly or implicitly, you're saying, get back or I'll shoot you. And but if you do that, you've technically checked all the boxes for aggravated assault with a firearm. And in Montana, that can be good for 20 years in prison, folks. I was involved in a case there where that's what the client was looking at. 20 years in prison. Didn't fire a shot, didn't hurt anybody. Just merely for having displayed the gun. And of course, we can understand why, right? Because bad guys often display guns for bad reasons, and we would want them held accountable. We don't want people waving guns at us. And of course, the people who are judging this conduct after the fact were not there. They don't know what actually happened. So the police, the prosecution, the judge, the jurors, they don't know if you were acting as a bad person for bad purposes or acting in lawful self-defense by presenting your gun. But if you're put to the test of a trial to settle that question, it could be very expensive, and there's never a zero chance of getting convicted. And if you get convicted, it's 20 years. So the stakes are pretty high. So some legislatures see a dilemma here. They see their constituents, law-abiding people, displaying a gun, getting charged with aggravated assault with a firearm, being put in peril of 20 years in prison, and spending a ton of money defending themselves in the legal process. And they're like, well, this shouldn't be. If someone displays a gun for lawful purposes, for self-defense, they shouldn't be subject to this kind of criminal prosecution, this kind of legal risk, which sounds reasonable enough. So then they pass these defensive display statutes that basically say, well, if you display the gun for purposes of self-defense, that's not a crime. All right, well, from my lawyer perspective, a technical perspective, that statute does nothing for you, because if you display a gun for self-defense purposes, it's never a crime. It's already not a crime. So the defensive display statute doesn't do anything for you. It still conditions the display on being in self-defense, which is a decision somebody else has to make after the fact. So I really believe that they're more feel-good statutes than anything else. I think legislatures, people who don't really understand how the law works, think they're getting more protection from having a defensive display statute on the books, and they're happy when their legislatures do that. And certainly there's no harm to doing it. I just don't think it provides people with the additional protection that they think they're getting. I personally would never present a handgun unless I was prepared to actually discharge that weapon. Now, maybe between the time I display and the time the shot would need to be fired, circumstances could change. The person who's attacking me could stop attacking me. They could throw their hands up. They could run away. So often the display is enough, and you don't need to fire the shot. So I wouldn't want people to understand me as saying that if you pull the gun, you have to shoot it. I'm not saying that. But I would not present a gun unless I believe the circumstances were met to actually fire that weapon. And then if hopefully, gratefully, the circumstances changed and discharge of the weapon was not required, then I certainly wouldn't discharge it if it wasn't required. But my gun is not coming out just to frighten people. Let's see. So one of the commenters here says, because I mentioned that our upcoming Saturday, January 8th class, our Law of Self-Defense Advanced class, is is just really a new badge we've put on what we've called before our level 1 class or our core class. If you sign up for the advanced class by mistake, folks, just let us know. Just email us. I mean, if you don't want to come again, we have many people take the class 3, 4, 5 times, by the way, because it is a fire hose of content. And they invariably tell me, my gosh, I know you must have said this thing in the previous 3 times I took the class, because the content doesn't change that much. But it only stuck in my head this 3rd time or 4th time that I heard it. That happens a lot. So just because you've taken the class before doesn't mean you should not take it again, folks. I would actually encourage you to take it again. I don't mean that just for reasons of profit. I mean, because the more you're exposed to the content, the stickier it becomes, and the more actionable it becomes under stress. But if you've taken the course before and signed up thinking this was a substantively different course, and you don't want to attend again, just email us and we'll be glad to refund your registration. Someone else will take your seat. I promise you. This is going to be a full class. Julius Newman says, law school's only 3 years. Yeah, 3 years. That's it. In fact, I was in a joint JD MBA program. So I actually went through law school in 2 years. It was an accelerated cycle for me, but it was 3 years worth of content. I attended classes both summers between first and second, and then the summer after second year. So I actually did it in 2 calendar years, but 3 academic years. But law school's, yeah, only 3 years. And then the bar exam, of course, which many people will spend some months studying for. A case of Brittany Smith in Alabama, shot and killed a man that raped her, later attacked her brother in her own home, lost her stand your ground, castle doctrine defense. So if it's the case I'm thinking of, and I believe it is, the problem there with that case, and this comes up a lot with cases where women shoot their purported rapist, is that it's often very ambiguous whether or not a rape ever occurred. The woman is claiming rape after the fact. After she's shot the person dead, often there's a lot of other dynamics going on. There's other reasons for animosity. It's just not a great relationship. There's it's a hot mess. There's often drugs involved. It gets really complicated. And claiming rape after the fact is not just a get out of jail free card. People have to believe. And by the way, you don't get to shoot your rapist after the fact anyway. I mean, we may want to live in that world, but you can certainly use deadly defensive force to stop a rape from happening. I would encourage all women, and for that matter, men, believe it or not, men are raped too. I would encourage everyone to be prepared to defend themselves against a rape from occurring. But if you've been raped, unlike the movies, you don't just get to go hunt down your rapist and shoot him dead. That's not how the law works. The justice system is supposed to take care of that. So it's my recollection of that case that this claim of rape seemed very ambiguous, very shaky, and that there were other apparent motives for wanting to commit that killing, which is why her case is not going well for her. Let's see. This is a good question. So someone's home, unwinding with a drink or two, say a few beers, and a self-defense event occurs with a firearm. Will the police and prosecutors throw the book at the defendant? Well, maybe it's in a sense an aggravating circumstance if you're intoxicated while you defend yourself. Now, you don't lose your right to self-defense because you've had a few drinks. You don't lose your right to self-defense if you're shit-faced. I mean, you still have the same privileges of self-defense. But if you make bad decisions or make apparent bad decisions that could be made to look as if they were bad decisions because you were drunk, that's on you. You don't get any special dispensation because you were intoxicated and made a bad decision. So you may get a sober person may get the benefit of the doubt on certain subjective decisions that a drunk person would not get that benefit on. I should also mention separately, and I do use of force law, folks. When can you use force under what circumstances? I don't do gun law, but there are many states that have separate gun law provisions that make it unlawful for you to be in possession of a firearm while intoxicated, even within your home. So you could face a separate gun law violation issue for that. Your argument there would generally be The necessity defense that, sure, you knew you were drunk and normally you shouldn't handle a gun, but the necessity of the circumstances prompted you to momentarily take possession of that gun in order to lawfully defend yourself. After the need for self-defense was over, you gave up possession of the gun, put it back away, for example. And that can be an effective defense. It's the same defense that felons often use when they use a gun for self-defense. The necessity defense, that they were only transiently in possession of the gun for purposes of lawful self-defense, and that's a legitimate defense in that case. Normally, in America at least, felons are federally prohibited, and usually also under state law prohibited from being in possession of guns at all. But you can argue the necessity defense for transient possession of a gun for purposes of otherwise lawful self-defense. That's basically the argument you would make at home as well. And that's the kind of law, too, where, there are states in America where they hate guns. They hate private ownership of guns. If they could ban private ownership completely, they would. My former state of Massachusetts is exactly that way. Alternatively, if you live in a place like Texas and you defend yourself in your home from an intruder, they may not care if you're shit-faced in Texas. But in Massachusetts, they'll take advantage of any opportunity you offer them to throw the book at you in a use of force case, especially a use of force case involving a gun. So that's kind of the part of the political dynamic of these charging decisions, even if the statutes in Massachusetts and Texas were otherwise, in terms of black letter law, identical. Let's see, what else do we have? Why can prosecutors throw lesser included charges? So for folks who don't know, a lesser included charge is, so you're charged with some criminal offense. Let's call it manslaughter. Manslaughter is an unlawful killing committed with malice. And a lesser included charge of murder would be any charge that has the same elements as murder, except it's missing one. So manslaughter would be a lesser included charge of murder because it doesn't require malice. I'm talking about voluntary manslaughter, not reckless manslaughter here. And it doesn't require malice because usually it's done in the heat of passion. For example, somebody comes home, finds their spouse in bed with a lover and shoots them dead. The law allows the argument that wasn't done with malicious intent. It was done in the heat of passion. So instead of murder, it's manslaughter. So one way to think of manslaughter is it's unlawful killing without the element of malice. If you add the element of malice, an additional element, then it becomes murder. Well, if you're charged with murder and the prosecution or the jury concludes that all the elements of murder were proven, except that malice was not proven beyond a reasonable doubt, well, now you don't have all the elements of murder because you don't have malice, but you still have all the elements of manslaughter, which does not require malice. So manslaughter is a lesser included offense of murder. When you're charged with one criminal offense, your defense attorney is effectively put on notice that you're also charged with all lesser included offenses. And there can be a lot of them. In the George Zimmerman trial, for example, he was charged with second-degree malice murder, which is essentially just malice murder. And then when the prosecution got to the end of the trial and realized their chances of getting a conviction on second-degree malice murder were basically zero because there was no evidence of malice, they hit him with every lesser included charge. I think there might have been 8 or 10 of them, all the way down to there was some kind of abuse of a child charge they tried to include, believe it or not, because technically Trayvon Martin was a minor. He was 17 years old. It was a legal argument never made during trial in front of the jury at all. But that's how desperate there was. So the state threw in every possible lesser included they could think of, and Zimmerman was acquitted on all of them on the grounds of self-defense. But that's just the way the law works. If the prosecution wants the lessers included, then they're going to be included, and the jury will be instructed on those. And the risk there for the defense, of course, is that often if you have so many charges, 10, 12 charges, once you include all the lesser included offenses, the jury might get the sense that, well, crap, this guy must be guilty of something. Look at all the criminal charges. So we don't believe he murdered him because we don't believe it was intentional. But we can't just acquit him. He must be guilty of something, and they'll come to what's called a compromise verdict, just something they feel comfortable convicting the defendant on, even if they haven't done the job of determining that each and every element of that crime was proven beyond a reasonable doubt. They're just picking it because they're comfortable with it. That's not supposed to happen, but unfortunately it does, and it becomes more of a risk of a lot of lesser included charges are offered to the jury. But often prosecutors don't like the lesser included because, well, they run the same risk from the opposite direction, right? They really want the murder conviction, and they're often afraid that if they include the lessers, the jury will go with the lesser and not with the murder conviction that they want. So ultimately, it's a judgment call by the prosecutor, how much risk they want to take or subject the defendant to. Someone's asking if I've ever considered publishing our book on LeanPub. I've never heard of LeanPub, but I guess I'll have someone take a look at that. We do have it on Kindle. So for those of you on Amazon, if you'd like to get the Kindle version. The one thing I don't like about the Kindle version, folks, is I generally encourage people to read our book like a textbook. So highlight things, underline things, put notes in the margins, date portions of it when you read them. Because if you do that, that book, in essence, becomes evidence of your state of mind, evidence of your specialized knowledge of the content of the book that could be admissible in court. And you can get that kind of specialized knowledge admitted as evidence if you can show that you knew it at the time you acted in self-defense, which, if you have a bunch of notes in a book, that's almost certainly enough evidence. You don't need a lot of evidence that you knew it. You need more than zero evidence. So a well-annotated book, a book with your own notes and comments and highlighting and underlining and so forth, is a substantive demonstration that you possessed that knowledge at the time you acted in self-defense. I'm not sure the equivalent is really possible in a Kindle book. I actually don't know if you can do that kind of thing in a Kindle book. But you can certainly do it in a physical book. And a physical book, you know, if you've had the book for a period of time and you've read it a number of times, and I encourage people to do that too, by the way, keep it on your nightstand or in the bathroom, or, you know, refresh your recollection of the content periodically. You know, you'll have made notes in different pen colors, and some writing will look older than others, and it looks less subject to having been, you know, fabricated as evidence after the fact than would a Kindle. But a Kindle, you know, I mean, you could do both and have the Kindle on your smartphone device, so it's always accessible to whenever you have a slow moment. Okay. Yes, so someone's asking, you can get the book in ebook form via Kindle, which is Amazon, obviously. All right, let's see. Let's see. Will there be live streams without the tie on? I don't know. My wife doesn't like those, so we'll see. And I trust her judgment. Let's see. Someone here says, I think Branka says that some states consider garages as not part of your house. Certainly an attached garage would be part of your house. A detached garage becomes more ambiguous. I would argue from the defense perspective that it's certainly part of the curtilage. It's part of your home. The normal day-to-day use of your home should be treated the same. But I can tell you for sure in Massachusetts and in Colorado. So Colorado has a very, very strong defensive dwelling statute. Most of you may have heard of it described as the Make My Day law. They don't actually use those words in the statute. Very, very powerful defensive dwelling statute. Does not apply based on actual trial cases, does not apply to a detached garage. So you get tremendous legal protection if you're defending yourself in your home from someone who's unlawfully present. I mean, it really privileges you to use deadly defensive force, even if you're not facing a deadly force threat. Any degree of threat would justify your privilege to use deadly defensive force under this Colorado Make My Day statute. But you do need to be in your home. And the court decision so far are that detached garage doesn't qualify for purposes of that Make My Day law. So again, when we get to property issues, they can become much more ambiguous than straight up self-defense. Someone here mentions John Lott's book, More Guns, Less Crime. Great book. Everything John does is great. John's been kind enough to, we're friends. I've known John for many years. He's given me a number of blurbs for our books and courses and such. So I would certainly encourage people to take advantage of everything that John Lott has to write on a public policy perspective. Is it legally permissible for a jury to disregard, and thanks for the super chat, BH, disregard all evidence and take out their dislike of a defendant by voting guilty? Cause for a new trial, if true. Well, generally, you don't know why a jury arrives at their verdict. So if a jury just decides they don't like you and wants to vote guilty, there's nothing to prevent that from happening. We give the jury all these instructions about their legal duty in an effort to convey to them the importance of doing it right. But if they want to convict or don't want to convict, they'll return the verdict they want. There's really nothing we can do about it. If there were, and it's almost impossible to appeal. Now, if it's a bizarre case where you can show that a juror was bribed or they had a family member taken hostage unless they delivered a verdict a particular way, then the fundamental process was broken by external factors. But we really leave up to the jurors in their own discretion how best to arrive at a verdict in the case. Let's see. Lamb Chop, thank you very much for your extremely generous super chat. He says, on Nate's stream, he brought up Minnesota Rule 606. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations. I haven't looked at that rule, and I'm not even sure what it's from. I mean, normally when something like that is called a rule, it's not a statute, a criminal statute that a juror could be held criminally liable for. I'd have to look at it. Nate's a good lawyer, so I certainly of course, lawyers were bred to disagree with each other, right? So I'm not saying if I heard Nate's complete argument, I may disagree with that complete argument. I don't know. But certainly my experience with Nate has been that he's a smart guy, good attorney. So there may be merit there. But generally speaking, after the trial's over, the jurors are free to talk or not talk about anything they'd like to say about the case. Thank you very much. Ardius paid me in euros. That's interesting. I wonder how that works. I still have some euros around here. About 10 or 12 years ago, I actually spent 2 years working in the Netherlands, where, of course, I was paid in euros. Euros is the currency there. And had a great time. Love the Netherlands. Maastricht, for those of you wondering where I was. The very south of the country. Above sea level. So was never in risk of drowning in the deluge. Thank you very much, AJ, for the super chat. All right, folks, I'm really going to focus here on the I can't even tell how many comments there are. They just never stop. Thank you, Ryan, for the super chat. Look forward to seeing you in the class as well. So just again, to remind folks, Saturday, January 8th, it's about a week and a half away. We're having our Law of Self-Defense Advanced class. We only teach it once every year or two. So if you missed this one, it'll be the last one for quite some time. It's a full day, plain English course of instruction on use of force law, American use of force law, the equivalent of a law school seminar on use of force law. If any law school taught this stuff at that depth, which they don't, you can gain true mastery of self-defense law in a single day, folks. And I don't know anywhere else that's possible. Not very costly at all. You can learn more about that at lawofselfdefense.com/advanced. And it is not this Saturday, but the Saturday immediately thereafter. So it's coming up quick at this point. Stinner asked, do I also shoot USPSA? I did. Maybe 15 years ago, I was shooting USPSA. When IDPA started, I was actually... So USPSA and IDPA, for those who don't know, are among what we call the practical pistol sports. Generally, they both started as sports in which you would shoot a kind of a normal semi-automatic or revolver, I guess, type pistol in competitive events. They were both originally defensively oriented. USPSA rather quickly became more of a almost like a video game with real guns, very fancy guns, specialized holsters, stuff you would not normally use for self-defense purposes. And when it became game-like, a second sport, IDPA, International Defensive Pistol Association, started. I was at the formation of IDPA. So IDPA, certainly, they must have 20,000, maybe 30,000 members at this point. My IDPA member number is 13. I helped edit the first rule book. I was at all the first 6 or 7 nationals working as a range officer. Before they even had a range officer certification program for IDPA, I had previously been a certified range officer or safety officer for USPSA prior to that. But I haven't shot USPSA in quite some time. I might go back because they do now allow for appendix carry in open class, and that's how I carry my gun defensively. So we'll see. I'll be looking around for places here in Colorado probably when the spring comes to do some USPSA. Let's see. All right. Scrolling for a super chat. Berensky. Anyone who uses a Glock is head flexible. Yeah. So Glocks are kind of tend to be kind of big in the grip, most of them. So they don't fit everyone's hands. And the sights on them suck, by the way. So if you buy a Glock, I do recommend it comes with plastic sights. They fly off the gun with some regularity. Get good metal sights put on the gun first thing. It's an extra $100, so I would kind of figure that into the price. Normally a Glock's around $500 or so. But you do want to put the good metal sights on it. Get rid of those. Sometimes the plastic sights, you can push them with your thumb. They come right off the gun. So I would change that. But they are extremely reliable firearms. Let's see. Hey, am I stepping on Nick's show? All right, that wasn't my intent. I wanted to be watching that Earl Grey interview myself. Let's see. Scroll for super chats. Looking for a super chat. Show me, man. This is crazy. So a super chat from Adhimur. Thank you very much. Says you can add notes, highlights, and bookmarks in the Kindle. That's good to know. Super chat from Chang. Hope to maybe see me at TACCon this year. Yes, I will be speaking at TACCon, Tactical Conference, again this year. I spoke last year. I speak there with some regularity, but they have invited me back for next year. This is Tom Givens' organization, fantastic instructor, Tom Givens, along with his wife. And they have a tactical conference every year. I would strongly encourage folks to take a look at that. If you Google TACCon, I'm sure it'll come up, and I will be one of the speakers this year. Did I carry a weapon in the Netherlands? Well, I don't know what the statute of limitations is in the Netherlands. I'm rarely without a weapon. Certainly not a gun. A gun in the Netherlands was not a viable option. Thank you, Stogies, for the super chat. And I think that's the end, folks. All right, so I've hit the bottom of the comments. Thank you so much. I'm sorry I was not able to share my screen. But I think once I reboot my Chrome browser, that'll be an option for next time around. I guess we won't really know until next time around. We'll have to try the technology again. But hopefully all of you found this enjoyable and informative. And I'll plan on doing it again next Thursday at the same time. I'll send out an email notice about that. I guess that's all I have for the moment, folks. So remember, if you carry a gun, so you're hard to kill. That's why I carry a gun, so I'm hard to kill, so my family is hard to kill. You also owe it to yourself and your family to make sure you know the law, so you're hard to convict. A great way to do that is to either get our book. You can get this at lawselfdefense.com/gethard for the hardcover version of the book, or even better, or both. Attend our upcoming Saturday, January 8th, Law of Self-Defense Advanced class, our full-day course of instruction on self-defense law. We only do it every year or two, folks, so if you miss this date, that'll be the end for a while. If that's of interest, point your browser to lawofselfdefense.com/advanced, and I hope to see a bunch of you there. And with that, I wish you all a safe and happy New Year. Take care.